So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
As we get ready for the retrial of the century up in Massachusetts, the Karen Reed retrial, every day is like another motion, another strange development in all of this. Now, underlying all of this is that the prosecution believes that Aidan Kearney, also known as Turtleboy, was communicating with Karen Reed, and Karen Reed was getting him to intimidate witnesses out there. That's part of their theory of what they believe was happening here. So they want to get the communications between Turtleboy and Karen Reed's attorneys. Strange, right? Take a listen to the arguments.
I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date, but those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth's pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it, and it provides a number of examples.
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that they act together in that respect, Your Honor.
The court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Now, you saw those two lawyers in there are two special prosecutors who had to be brought in here. One is the special prosecutor prosecuting Turtleboy for allegations of witness intimidation. The other special prosecutor is the one prosecuting Karen Reed. And the cases are like crisscrossing all over the place. But let's try to make it a big picture here. So, Paulette, is it fair? Is this some sort of conspiracy? Is this illegal? Is this untoward? What is it if Karen Reed and her team are giving information to a member of the media, which is what he is? It's the new media that exists today, but giving information to a member of a media about a case. Like, is this a huge problem here?
I think it may be. Obviously, they want to spin things in their favor. And we saw from the first trial, it worked. There was always more supporters for Karen Reed than the poor gentleman.
Well, let me ask you this. This is really the way I'm looking at this, so you understand. So, and I'm a former prosecutor. Like, we come out, we accuse someone, we have an indictment, we bring him into court, sometimes there's a perp walk, there's a statement about the arrest, all of that, and we lay out our case, prosecutors do. And this seems like it's like the defense trying to do the same thing as they're finding out information and trying to get the media to cover the other side of the story. Why is that not fair? And Philip Dubé is just shaking all over the place. Paulette, I'll let you finish, and then we'll go to Philip.
Sure. So I agree with your line of thinking. That should be, the way that it works for defense to at least level the playing field. But how the prosecution is going to flip it is they're going to say, if Miss Reed truly was innocent, she wouldn't have to do all this because she would have no doubts that the jury would look at the evidence and find her not guilty.
And you know what's interesting, Philip, is that this is a very aggressive prosecution, and they want all this new information. Why do they need all this new information if they believe that she committed, like, this is information that's after the fact? They indicted her years ago before any of this information even existed. Why do they need that to prosecute her? Like Paulette said, well, if she's innocent, then the evidence isn't there. But if she's guilty, the evidence should be there. Why is it a sign of desperation that the prosecution is digging and digging and digging for more and more and looking for attorney communications now?
Well, first of all, I respectfully disagree with the Commonwealth's tactic of trying to get those communications. Separate and apart from attorney-client privilege, they have in the Commonwealth of Massachusetts and even out here in California, the work product doctrine. And what work product says is that anytime you have a defense attorney working on a case, that lawyer's impressions, investigations, conclusions, and theories of the case enjoy a special privilege from discovery. You don't have to turn that over, and that dates all the way back to high court precedent, I think, from the 30s or the 40s. So I take exception to this notion that an attorney is trying to get work product from a defense attorney. It's just repugnant. Now, having said that, I don't know that I would call it desperation, but they suffered a great defeat in the first trial in that it was a deadlocked jury. In order to prevail in this case, they're going to have to convince a whole new crop of 12 that she committed murder. And the problem is their lead detective has been defrocked.
Yeah, he has. And the first jury, and honestly, the first jury, found her not guilty of murder, but they didn't fill out the paperwork. Silva, I'll give you the final word here before we run out of time. What are your thoughts about all of this stuff happening right now on the eve of the retrial?
Vinny, I do think it's desperation. I completely agree with what Philip is saying. It's a last-ditch effort to try to get a hold on this case because honestly, about 20 years ago, even 10 years ago, defense counsel always told their clients, don't talk to the media, don't talk to the media. And that's usually what we do for success. Karen Reed's case is so exceptional. From her doing the HBO Max documentary where she's like, I can finally be heard, to the media getting involved so deeply, she has an incredible and obsessive following that believe that she's innocent. And Vinny, everything the defense did the first trial worked in their favor. I do think the prosecution is trying everything in their power to take every advantage from the defense away because they believe that's the only way they can win this trial. Honestly, the media push from the defense is working. And also what the defense is putting forward right now is also working. I think the prosecution really needs to stick to their legal theories. And just as Philip said, leave the attorneys out of it. Attorney-client privilege is sacred and shouldn't have even been argued about.
I agree. All right. Great job, everyone. Thank you so much. Paulette Lofton, Philip Dubé, Silva Megerditchian. We appreciate it. When we